Ready? 1, 2, 3, start. The court could then return the plaintiff for presentation to the proper court, but it was not quite just to dismiss the application for amendment on the consideration that if the amendment were allowed, jurisdiction of the civil courts would be ousted. Stop. Reliance was placed upon a ruling of the Hyderabad High Court in case of Govardhan Bain versus Government of the Union of India, AIR 1953, Hyderabad 2012. Stop. Para. Learned counsel for the respondents relied upon a ruling of the Madras High Court in the case of Singara Mudaliar versus Govind Swarni Chetty, AIR 1928, Madras 400. Stop. In that case, the suit was filed originally in the city civil court, Madras, and was transferred to the High Court in exercise of its extraordinary original civil jurisdiction. Stop. Later, an application to amend the plaint was made, the effect of which was to convert the suit into one which the city civil court within bracket the forum originally closed by the plaintiff bracket close would have no jurisdiction to try. Stop. Para. It was held that the amendment could not be allowed as the powers of the High Court under class 13 those of the city civil court itself. Stop. Learned counsel also argued that the application of the plaintiff for amendment was very much belated, as he did not file the application for amendment, although the question of non-maintainability of the suit on account of want of possession had been before him almost as soon as the suit was filed. Stop. Para. I have considered the arguments of both the learned counsel. Stop. Para. It is true that if the suit as framed were beyond the jurisdiction of the lower courts, they would have had no jurisdiction to make any amendment. Stop. However, from the plaint as it stands, it cannot be said that the lower court had no jurisdiction in the suit when it was filed. Stop. The civil courts would have been, therefore, perfectly justified in exercising their powers of amendment, even though the consequence of the amendment would be that the suit might become beyond the jurisdiction of the civil courts. Stop. If as a result of amendment, the suit becomes one not cognizable by civil courts, they would have to return the plaint for presentation to proper court. Stop. Para. It very frequently happens that the suits are undervalued in the beginning and the objection is raised and the valuation is increased, with the result that in some cases, the case goes out of the jurisdiction of the court in which it was filed, and then the plaint is returned for presentation to the proper court. Stop. It cannot be said that because at a large stage it becomes out that the suit is not within the jurisdiction of the court in which it was filed as a result of amendment, the court in which it was originally filed had no jurisdiction, from the very beginning. Stop. I am, therefore, inclined to agree with the ruling of the Hyderabad High Court in the case cited above within bracket AIR 1953 Hyderabad 212 bracket close. Stop. It was held that. Stop.